On March 23, 1944, the bodies of two young girls, Betty June Binnicker and Mary Emma Thames, were discovered in Alcolu, South Carolina. The girls had gone missing the day before, as they never returned home the previous night. Binnicker and Thames both suffered severe blunt force trauma, resulting in penetration of both of the girls' skulls. A 14-year-old African-American boy, George Stinney, was tried and convicted of the murders. He was executed by electric chair in June of 1944, thereby becoming the youngest American with an exact birth date confirmed to be sentenced to death and executed in the 20th century. Hey friends, I'm Xavier, and I'm back with another Black Case file for you. Anyways, there's been a lot going on. I'm trying to get more consistent again. Just bear with me. Anyways, I typically talk about cases that tend to focus on people of color, and the topics vary. Sometimes it's about murder. Sometimes it's history. Sometimes it's mystery. Sometimes it's conspiracy. Sometimes a murder, mystery, conspiracy from history. Anyways, if you like this content, make sure to hit that lovely red subscribe button. You can also find me on Instagram at the Black Case Files. Lastly, I have a little playlist that I add all of these to, so that should be showing right there. Binge it, have fun, enjoy. Okay, let's get into it. This tragic story takes place in the Jim Crow South. George Stinney was approximately 14 and was living in Alcolu, South Carolina with his parents, two brothers, and two sisters. His dad worked at the town sawmill, and the family of 7 lived in company housing. Alcolu was a small town. Everything was segregated, as was pretty standard at the time. However, all of that changed on March 23rd when 2 little girls were found. The girls were last seen riding their bikes looking for flowers, looking for passion flowers, or as it was called at the time, maypops. As they passed the Stinney's property, they asked George and his sister Amy, who were outside, if they knew where to find them, the maypops. Well, according to Amy, she was with George at the time the police later established for the murders. After failing to return home the night before, a search broke out looking for the girls. The bodies of Betty June Binnicker and Mary Emma Thames were found in a ditch on March 23rd, 1944. The bodies were discovered on the African-American side of Alcolu. The girls had been beaten with a weapon, which was variously reported as a piece of blunt metal or a railroad spike. Next day, the sheriff announced the arrest of a George Jr., stating that this George Jr. had confessed and even led officers to a hidden piece of iron. However, according to his family, in particular his sister Catherine, he had no middle name, and nobody knows where it came from, where the Juniors came from. She's reporting and saying, "And why Juniors? That's an awful name." His full name was George Stinney Jr. Well, George Stinney Jr. and his older brother John, they were arrested on suspicion of murdering the girls. John was released by police, but George was held in custody. He wasn't allowed to see his parents until after his trial, and that's the only time they saw him after his trial and conviction. The arresting officer of George was H.S. Newman, a Clarendon County deputy, who stated, "I arrested a boy by the name of George Stinney. He then made a confession and told me where to find the piece of iron about 15 inches, where he said he put it in a ditch about 6 feet from the bicycle." George was questioned alone without his parents or an attorney. Remember, this is pre-Gideon versus Wainwright. Although the Sixth Amendment guarantees legal counsel, this was not routinely observed until the United States Supreme Court's ruling in Gideon versus Wainwright. And that ruling explicitly required representation throughout the entire course of criminal proceedings. Investigation following George's arrest, his father was fired from his job at the local sawmill, which means his family lost their housing and they had to immediately vacate. Again, this is the Jim Crow South, so the fear and threat of lynching was not empty. To get an idea of what it was really like, you can check out my discussion of the Groveland Four, which should be right there. Sadly, George's parents, as I said before, they didn't see him again before the trial. George didn't have any support during the 81-day confinement and trial. 14. He was detained at a jail in Columbia, about 50 miles away from Alcolu, because of the risk of lynching. However, 50 years later, in 1995, there was an interview regarding George by his 7th grade teacher, W.L. Hamilton, who was stated as saying, "I remember the day he killed those children. He got into a fight with the girl at school who was his neighbor. In those days, you didn't have to worry about children carrying guns and knives to school. But George carried a little knife, and he scratched this child with his knife. I took him outside, and we went for a little walk, and I talked to him. We went back into the school. In a submissive way, he begged for the child's pardon." George's family was fiercely protective of his legacy, and they denied this, and his sister, Annie Ruffner, contacted the teacher after it was published. Amy stated, "I asked why would he say something like that?" Well, he told her someone paid him to say it. And she said, "I don't know who paid him, but his exact words were, because they paid me." The teacher, Hamilton, died a short time after this interview was published, and there's a local white woman who says she remembered Stinney from childhood and claimed in 2014 that he had threatened to kill her and a friend the day before the murder, and that he was known as a bully. The entire proceedings against Stinney, against George, including jury selection, took place on April 24th, 1944. Again, this was pre-cross-section of the community, so the jury was an all-white male jury. George, he was provided counsel by the court, Charles Plowden. However, he seemed to have his own agenda, which did not include George's rights, as he was a tax commissioner who was campaigning for election to local office. So it's not really a surprise that Plowden didn't challenge the 3 police officers who testified that George confessed to the 2 murders. He also did not challenge the prosecution's presentation of 2 differing versions of George's verbal confession. 14. In one version, George was attacked by the girls after he tried to help one who had fallen in the ditch, and he killed them in self-defense. In another version, he had followed the girls, first attacking Mary Emma, then Betty Jude. There is no written record of George's confession apart from what Deputy Newman said, saying that he confessed. That's it. Today, these reports would have been suppressed. However, the protections that have been established now, about 80 years later, were not available to those who looked like me and George. Now, I think it could have been suppressed as being a violation of all of these things the police are saying as a violation of George's 5th, 6th Amendment rights, and everything stemming from this investigation would be considered fruit of the poisonous tree and would be suppressed. Other than the testimony of the 3 police officers, the prosecution called 3 witnesses: a Reverend Frances Pollock, who discovered the bodies of the girls, and 2 doctors who performed post-mortem examinations. The court allowed the discussion of the possibility of rape due to some peculiar bruising, but again, Plowden didn't call any witnesses, didn't cross-examine the witnesses, offered basically no defense. The presentation of evidence lasted 2.5 hours, and after less than 10 minutes, the jury found George guilty of murder. The judge sentenced George to death by electrocution. Currently, there's no transcription of this trial, and no appeal was filed by Plowden. George's family, churches, the NAACP appealed to the governor at the time, Allen Johnston, for clemency, given the age of the boy, 14. Others urged the governor to let the execution proceed, which the governor did. The governor visited George in death house 2 days before his execution, and he wrote a response to one appeal for the clemency saying, "I have just talked with the officer who made the arrest in the case. It may be interesting for you to know that Stinney killed the smaller girl to rape the larger one. Then he killed the larger girl and raped her dead body. 20 minutes later, he returned and attempted to rape her again, but her body was too cold. All of this he admitted himself. However, the autopsy completely refutes this. It proved these allegations were absolutely false. George was executed on June 16, 1944 at 7:30 p.m. He was prepared for execution by the electric chair, and he had to use a Bible as a booster seat because he was too small for the chair. He was then restrained, arms, legs, body of the chair, and an officer asked if he had any last words before the execution, but he shook his head. The executioner pulled a strap from the chair and placed it over his mouth, causing him to break into tears, and then he placed the mask over his face, which did not fit him, and he continued sobbing. When the electricity started, the cover slipped, showing the tears falling down his face. Families of the victim claimed the story was false, saying that they saw it and nothing like that happened. Obviously I wasn't there, so I can't say, but I do know he was 14 when he was electrocuted by the electric chair. He was buried in an unmarked grave in Crowley. About 60 years later, there was a reopening of George's case in 2004. A local historian, George Pearson, who grew up in Alcolu, started researching the case after reading a newspaper article about it. It was through his work that the attention of South Carolina lawyers Steve McKenzie and Mount Burgess started looking into his case. In addition, Ray Brown, James Moon, and others contributed countless hours of research, review of historical documents, and found witnesses and evidence to assist in exonerating George. Among those who aided the case were the Civil Rights and Restorative Justice Project, CRRJ, at the Northeastern School of Law, which filed I call it amicus, but they filed an amicus brief with the court. Some people call it amicus. It was in 2014. These lawyers sought relief through the Pardon and Parole Board of South Carolina, and these attorneys representing George's family, filed a motion for a new trial in October of 2013. They said, if we can get the case reopened, we can go to the judge and say, there wasn't any reason to convict this child. There was no evidence to present to the jury. There was no transcript. This case needs to be reopened. This is an injustice that needs to be righted. They were stated as saying, I'm pretty optimistic if we can get the witnesses we need to come forward, we'll be successful in court. They found witnesses who were non-family, non-relative, who might be able to tie all of this in. Basically an alibi witness who was there with George and could say this did not occur. Later on, it came out there was a deathbed confession. It's questionable, but there was a deathbed confession from a rumored culprit that came from a well-known, prominent white family. A member or members of that family had served on the initial coroner's inquest jury, which recommended that George be prosecuted. In its amicus brief, it was stated that there is compelling evidence that George Stinney was innocent of the crimes for which he was executed in 1944. The prosecutor relied almost exclusively on one piece of evidence to obtain a conviction in this capital case, the unrecorded, unsigned confession of a 14-year-old who was deprived of counsel, parental guidance, and whose defense attorney shockingly failed to call witnesses or preserve his right for appeal. New evidence in the hearing in January 2014 included testimony by George's siblings that he was with them at the time of the murders. In addition, an affidavit was introduced from the Reverend Francis Bastion, who found the girls and pulled them from the ditch. In his statement, he recalls there was not much blood in or around the ditch, which would lead one to believe that the girls may have been killed elsewhere and moved. Wilford Hunter, Johnny, who was in prison with George, testified that George told him he had been made to confess and had always maintained his innocence. Well, here's where the court did something rather unusual. Usually, they would just vacate the conviction and remand for a new trial. Well, we have a situation where everyone is now deceased, so rather than approving a new trial, in December 2014, Circuit Judge Carmen Mullen vacated George's conviction. She ruled that he had not received a fair trial and he was not effectively defended and his Sixth Amendment rights had been violated, egregiously violated. The ruling was a rare use of the legal remedy known as coram nobis. The coram nobis is a Latin term applied to common law to call to the court's attention facts that would have changed the judgment but were outside of the record and unknown to the court at the time of judgment. The writ of coram nobis is intended to correct the final judgment by the same court in which it was rendered by readdressing a fundamental error such as a deprivation of the right to counsel in violation of the Sixth Amendment. I think that fits pretty well here. Judge Mullen ruled that his confession was likely coerced and therefore inadmissible. She also found that the execution of 14-year-olds constituted cruel and unusual punishment, and that his attorney failed to call exculpating witnesses or to preserve his right of appeal. The judge confined her judgment to the process of the prosecution, stating that, George may well have committed this crime. However, no one can justify a 14-year-old child charged, tried, convicted, and executed in 80 days. In essence, not much was done for this child when his life lay in the balance. Now, family members of the murdered girls expressed disappointment at the court's ruling. They do acknowledge that 14, it's controversial, but they never doubted his guilt. The family claimed they extensively researched the case and people just read these articles and papers, don't know the truth. But it makes you wonder. It's still a 14-year-old child. You had a lot of evidence to the contrary. The only evidence really that convicted him was he was a convenient person to pin the murders on. Anyways, since George's exoneration, the son of a wealthy white businessman, I'll not say his name right now because there's still question. He's been the subject of speculation as a possible subject for the murders, but the family was involved in the initial search. The family members of this particular person were involved in the initial search and the initial reports and the coroners. It just brings up a lot of questions. As I've said before, as I said on the Groveland 4, as I'm saying now, people who look like me and George, equal access to justice was not equal access to justice. I know that was a heavy one, but thanks for sticking it out. I'll catch you next time. Thanks for checking out the Black Case Files, and there's a couple more. We'll probably stay away from something so heavy next time. But thanks again. I will be uploading some more very soon. Catch you next time. Bye.